Good afternoon, class. I would like to welcome you to today's class. And I want to believe that you can hear me clearly. So we're going to pick it off from where we stopped in our last class. And that means we will be starting with the topic sources of Nigerian law. And of course, this is not completely new to everyone on this platform. These are topics that we have treated with other levels, but it's important that we take it, at our own class here, so that we'll be able to have more clarity. And if there are areas that you're not clear with, you will be able to ask questions. So I would like you to pay attention so that at least you can follow through with what we have to say in the course of this class. So again, I repeat, the topic before us is sources of Nigerian law. And when we're talking about sources of Nigerian law or sources, we refer to what is popularly called fountain of authority of a rule of law. That is where law originates from. And it can also mean the body of a Nigerian legal system. That is the compendium of the Nigerian legal system, or where the laws of Nigeria they are obtained from. And one thing we have to stress in the course of this class, as we have done previously, is that our history has greatly influenced the sources of our law, or where our law came from. And this history has in a great way helped to develop or to identify quickly where we got our laws from, or parts of where we got our laws from. Sorry, just a minute. Your coordinator is talking to me. Okay. So your coordinator is trying to say that we stop at the features of Nigerian legal. Treated that particular topic. What is next is the sources of Nigerian law. And that's why we are taking on what the sources of Nigerian law. And we have established that our history has influenced greatly the sources of our laws, or what we can easily call the origin of our laws. So, following the colonization, or what we call the imposition of British rule, right from 1861 and 1914 up down, English law was introduced in different parts of this country. And with that, English law has formed a bulk of the laws that we have in our system as a people. So this history, like I said, cannot be put aside. And then we are going to look at these various sources and how they relate to the issue that we have raised as to how our history has influenced the sources of our laws. So for the purpose of this class, we are going to be looking at about 7 sources of Nigerian law, and this includes the Nigerian legislation, that's number 1, followed by the received English law as a source of Nigerian law. We also have case law as another source of Nigerian law. We have customary law, we have Islamic law, we also have international law, and we also have what we call the opinion of jurists and legal writer. So these are the identified sources of our laws as a nation. And I repeat these sources again to include Nigerian legislation, received English law, case law, customary law, Islamic law, international law, then opinion of juries and legal writers. So all of these sources that we have identified, we are going to take them one after the other for purposes of digging deep to know exactly what they mean and how they affect or the role that they are playing in our legal system. And the very first one we are going to look at is the Nigerian legislation. The Nigerian legislation, which we can also refer to as statutes, is a law enacted by a legislature and usually in a written form. And in Nigeria, as a people, we know that we have the arm of government that is saddled with the responsibility of law making, and that is the legislative arm of government. So these laws made by the various arms of government of the states or for Nigeria, the National Assembly for Nigeria, are the laws that we refer to as Nigerian legislation. So simply put, it can be said that it is or this is a law made by the established organ of government with the responsibility of law making. So laws enacted by House of Assembly is expected to meet some prescribed legislative procedure. That is, the law must, as a matter of fact, comply with the procedure that has been laid down for lawmaking. And when that particular piece of legislation has gone through the required procedure, automatically the law or that particular instrument or writing becomes an active law in our nation. So legislation is a powerful and exigent source of Nigerian law. That is, Nigerian legislation is a powerful and exigent source of Nigerian law, and then it is the deliberate exercise of lawmaking powers by the recognized body, which, with the power to make law. So, and that's why we see Nigerian legislation as the most important instrument of legal development and source of Nigerian law. Why? Because the law itself, or the laws of Nigeria, some of them are the ones that give validity to every other laws that may want to come into our system as a people. So, therefore, Nigerian legislation as a source of law is very, very important. And it is, it has a lot of effect on so many other laws that operate in Nigeria. For example, the Constitution of the Federal Republic of Nigeria is the law that empowers every other law that may exist in the Nigerian state. And the Nigerian legislation is a product of the active exercise of lawmaking, or the exercise of lawmaking within the Nigerian system. And for any foreign law to have its way, or be active, or be deployed, or be reckoned with in Nigeria, such law must have been domesticated, or ratified, or empowered by the Constitution of the Federal Republic of Nigeria. So, therefore, what are the examples of, or the types of legislation that we have in Nigeria? One is ordinances. Ordinances are those statutes which were enacted by the Legislative Council, which then legislated for Nigeria. Okay, you recall that we talk about our colonial history, how our colonial masters imposed their laws, imposed their system on us, and therefore it has become what we practice today. But before Nigeria as a nation started having its own body with the power to make law, has been governed by laws made by the colonial masters. And at that time, like we saw in history, that it was the colonizers who were making their laws available for the laws were applicable to citizens of this country. So the laws made by those legislative council as at that time is what we refer to as ordinances. And that is a type of Nigerian legislation, having been accepted as a legislation, as a legislation that can be enforced, or that is can apply to the territory of Nigeria. Another example, another type of legislation in Nigeria is what we call acts. ACTS. Act simply means federal laws enacted by the federal legislature. For example, any law made by the National Assembly of the Federal Republic of Nigeria is referred to as an act. We also have laws as another type of legislation in Nigeria. Law in this sense, are federal laws, and there are state laws enacted by the state's arm of, by the state, which is a unit of the entire country. And these laws are made by they are made by the legislature, which is the arm of the state government that can make law for the states. So, example of types of legislation that we have, I've mentioned ordinances, I've mentioned acts, I've mentioned law. Another type of legislation that we have is decrees. Decrees. They are laws made by the central law-making body under a military system of government. Even though the military are not to rule, they have their function to perform, which is different from governance. The president of the country, who happens to be the commander-in-chief, is the one who gives them authority to do. So they don't have the original duty to govern. But in a case where they take over power, like we have in neighboring countries now, the kind of law they make at the center is what is known as a decree. I believe there should be nobody in this class who will not know what a decree is. But for purpose of people like that, we have explained that decrees are law made by the central law-making body under a military government. The opposite of it is edicts. Edict is spelled E-D-I-C-T-S. These are laws made by the law-making body of a state during a military regime. So while we have acts as law made by the federal, we have law as law made by the state under civilian regime. So also we have decree as law made at the central, while edicts are law made by the state. Another type of legislation we have is bylaws. Bylaws. These are, can also be referred to, the bylaw we have here is spelled B-Y-E laws. It can also be referred to as B-Y law, that is B-Y-L-A-W-S. So these are laws enacted by local government council areas in the areas that we have powers to make law. Maybe an area that has to do with collection of rates or dues from market women, management and maintenance of peace, and then provision of social amenities as the case may be. So those are the basic function, basic types of Nigeria legislation. Balogun, you are raising your hand. Yes, can we hear you?
Yes, I have a question, sir.
Okay.
Sir, are all military system of government coup d'etat?
They come into power through coup d'etat. Okay? Because
Okay.
they are not elected. When you look at the election that brought in President Bola Ahmed Tinubu now, it was conducted and the Nigerians who were eligible to vote were made to vote. But for the military, they usually come in by force. Either they kill the president through what we popularly, technically known as coup d'etat. Was I able to?
Okay, sir.
All right. So, that is the different types of legislation that we have. So what we are going to do now is the legislative process. Okay, we're going to look at the legislative process, that is how laws are made in Nigeria. So we are particularly concerned with the making of legislation and the reason for the legislation and the legal reasoning that underpins the legislative process. Of course, you may have seen, some of us may have visited the National Assembly before and see how they make law for the country, the steps that they must take, the procedure they must embrace in order for them to pass a law that is considered to be a valid law under the Nigeria legal system. So that is, those are the various examples of Nigerian legislation that we have. So now let's talk about the legislative process. Okay, that is how the laws are made. But before I talk about that, it's important that I mention reason for legislation. What are the reasons why legislations are put in place? And if I ask everybody in this class, we'll be able to provide answer that it is needed because of the nature of modern society. The society changes from time to time, and therefore there is need for the local laws of the land to change in order to meet the end of justice. So one of the reasons behind making of legislation is to meet the ever changing needs of the society. Another one is for consistent advances in science and technology. In this era, the age that we have now, we see various things that were not in vogue at some certain time. They now form part of our life. One of it is what is known as artificial intelligence. These days now, artificial intelligence has been able to do many things for man that has made life to be very easy for man. Okay, that's made life to be very, very easy for man. So because of this change, there will always be need for the states to make laws that will help to manage the society. So that's one of the rationale behind legislation. Another one is due to the ever-changing government policy. You see that government come and go every now and then, and the policies they make have consequential effect on law making, on the lives of the members of the society. So there is always need for law to be made in order to regulate the society. Okay, so that is another reason. The another reason for lawmaking is for the purpose of maintaining law and order in the society. And just like we have established in recent times, that if there is a society that does not have law, that society is heading for anarchy, because everybody will want to do what he or she likes. And if everybody is doing what they like, eventually there will be chaos, and then the society will become a society that is free for all to do what they want. And that alone, again, is not good for the development of the society. And then another reason is that it regulates the different aspects of our lives. For example, in Nigeria now, we have laws on land ownership, we have laws on marriages, we have laws on education, and so on and so forth. Okay, so those are the rationale behind law, behind legislation. So, and therefore, these reasons, as important as they are, help to shape the society. So, and I've mentioned types of legislation before now, and we'll just look deeply into types of legislation again. These are other types that we can also refer to in the process of explaining this topic. Like we have public general acts as a type of legislation. The public general acts are laws or legislation that is applicable to everyone and everywhere within a particular country. In the case of Nigeria, any law that applies to everybody in the country is known as the Public General Act. We also have we also have types of legislation that we call private act. Private act is one that is a law that applies to a specific person or body of persons. For instance, such legislation may apply to particular individuals. It may also apply to private corporations like Water Board, like INEC, like NDLA, and other local authority that manages life of citizens within the society. Another type of legislation is what we call the local act. This type of legislation focuses on and apply to particular locality within a particular country. In the case of Nigeria, within Nigeria. An example of this local act is in Nigeria is the Northeast Development Commission Establishment Act. I'll repeat that again. The name of the law, even though it's very long, but we have to note it, is known as Northeast Development Commission Establishment Act. So this one was enacted to, among other things, address poverty, address illiteracy, address ecological problems, and other development challenges that pertains to the Northeast state of the Federal Republic of Nigeria. So you will see that it's an act that does not apply to generality of Nigerians. Rather, it applies to the Northeast. Okay, so that particular Northeast Development Commission Act was established in 1917 to cater for issues relating to poverty, illiteracy, ecological issues within those particular locality. Another one that we have here as a type of legislation is what is known as Consolidating Act. Consolidating Act. This is a legislation that reenact an earlier legislation. That is, maybe the law was in place before and it was displaced. This particular Consolidating Act can bring alive that which has died. Okay, and then either do some form of modification or build it up to meet current demand. Then another example or type of Nigerian legislation is a code. A code. A code is an act that comprehensively set out the extent of legislation as well as the common law and equity on a defined subject. So this code set an act that comprehensively set out the extant legislation as well as common law and equity on a particular matter. Example of this code is the Company and Allied Matters Act 2020, which puts together all the law governing the formation and management of company in Nigeria. So that means if you want to register a company in Nigeria, you must follow through to abide by the provision of CAB, which is Company and Allied Matters Act. Okay, so we quickly look at how laws are made at the National Assembly. So what we call legislation often begin with a legitimate proposal, which eventually translates to a bill. So when you see laws that have been made, ordinarily they came by way of proposal and say, okay, we are honorable member representing Lagos State, and then we are coming with the view of enacting law that will take care of the transport need of Nigeria, of Lagos State. And that, therefore, that's a proposal. But that proposal can be translated into what is called a bill. Then the bill is then presented to Parliament, from where it undergoes a process of rigorous scrutiny and debate before it validly becomes law. So if they are making law for the entire state or country, they are made to go through all the various stages so that there will be no error. Apart from so that there will be no error, so that they will know exactly whether this is a kind of law needed by the government. Needed by the citizen of the country. So, therefore, what form should a legislative proposal take? It does not require any special or particular form. However, it is expected that the proposal will specifically mention the subject that forms its object. That is, when you want to, when you want to
Sorry, excuse me. Am I the only one not hearing our lecturer again?
You are not the only one. I think there was power outage or power surge or something. So I lost connection. I'm back now.
Oh, all right. No problem, sir.
All right. So the process simplified is that when you have your proposal, it is submitted to either the law reform agency or um or bodies that can help scrutinize the law in order to make it a presentable instrument which the parliament can dwell on. So when it has been strengthened out, the proposal is further developed into what is now called the legislative bill. And it is this legislative bill that goes to the State House of Assembly or National Assembly, where it eventually goes through other processes before it becomes law. So, like we said before, the process of lawmaking is usually very rigorous, but the law provides for the procedure for lawmaking in our constitution. I'll refer you to section 58, sub 1 to 5, and section 59, 1 to 5 of the constitution. They contain those factors, they contain those things that you must do, what the House of Assembly must do in order to come up with a valid law. So the bill is expected to become law after it has gone through these processes, and then the president signs the bill. So the first stage is that the bill will be introduced on the floor of the House, and it will be read in that House. And then the aim of the first reading is to simply draw the attention of the legislators to the bill and generally acquaint them with its subject matter. That is what the law wants to address. And there is no debate on this bill at this stage. After this particular stage, copies of the bill are distributed to legislators, and they are made to read it for a second time at a later date. Then another thing that happens is that the bill is then referred to a standing committee of the House. You will be hearing different committees in the House. There are committee on transportation, committee on legal, committee on this. So what they do in those committees is that they are made to give suggestions, valid suggestions to the proposal that have been put forward as a form of a bill. For example, now in this class, we have people that are being trained to become mass communicators. We also have people who are being trained to become library scientists. There is no way that somebody who is trained in that way, who is trained as a librarian, will not do better than someone who is not trained in that line. So when issues of that comes up, they pick people in the committee who already have experience over the subject matter in order to review what the proposer is talking about. So at that stage, there is more reading of the bill, and then at another stage, the legislature are expected to debate the general principle of the bill and ask questions from those who are putting it forward. And this usually leads to some form of debate. And this debate is just to be able to get the best out of the bill that has been presented for deliberation. And then the bill through the committee can help the House to see whether it was well drafted or not. Then at another stage, the committee can make alteration to the bill that has been proposed, being that they are the ones that are in the House. They know how the alteration will be done to meet the end of justice. And then eventually the legislature will then vote on the bill. The bill is usually passed by a simple majority of vote cast by the legislature. Therefore, a bill passed by a particular house of the National Assembly must be sent to the other, where it is expected to undergo the same process as we have stated above, and any amendment or alteration made to the bill by the other house must be agreed by both houses before the bill is finally sent to the president, who is duly bound to give his assent or acceptance of the bill. And when he signs it, it becomes a law in the country. So these are the process or the procedure of lawmaking. Now, I need to point out here that when the bill is sent to the president may choose to append the signature, or he may not, depending on what is contained there. The president may send the bill back to the House for them to remake it, or to remove some things that he consider that will not be in the interest of the nation. And when the president does that, the House of Assembly, they are duty bound to look at the point the president is making, and then go either make amend and represent it to the president. But where they believe that the president is not saying anything and is not willing to sign the bill into law, the House of Assembly is empowered to override the president by exercising their powers and voting. And once they vote, once 2/3 of the total member agree that it should be passed, it automatically becomes law, even when the president is very unwilling to sign the document. So with that, we are talking about the legislation and how legislation are made. And then we have to stop the class here because I need to attend to the exams that is going on in the faculty. Do we have any question from anybody? Any question on this legislative process? Yes, I'll take just 2 questions and then we can call it a day. Yes, Mamu Yowi, let's hear you and show you one.
Good afternoon, sir.
Yeah, good afternoon.
So you said bylaw is also called what?
The bylaw is spelled BYE, but we also spell it BY. You get?
Oh, okay, sir. Okay.
Yeah, that's an so
Yes,
that
sir.
when you see the various spelling, you will not be confused as to what we are saying. Okay?
Okay, sir.
Yes.
And also, you said local art focuses on what? I didn't get that. Sir.
You said what?
You said local art focuses.
Yes. As a type of legislation, it focuses on peculiar or particular localities. That is the need of a particular locality. Okay? And that was why we gave example of Northeast Development Commission Establishment Act of 2017 that deals with the development of the Northeast. Yes.
Okay, thank you, sir.
Yeah. Any other question before we call it a day?
Yes, sir. Good afternoon, sir.
All right. Good afternoon.
So you said under types of legislation that
Yeah.
acts and laws are made by civilians, right?
Yes.
And
What?
while decrees and edicts are made by military government. So is
Yes.
bylaws now made by both civilians and military local governments?
Where at that stage, there are usually no room for like all those local government set up because the system is usually not the usual procedure, but the state makes law that governs whether both the local government most of the time, and then they just have their way. They are not like the military is not the usual organized body like we have during the civilian rule. So basically, it can either be there or there, but the bylaw usually comes in during the civilian rule. Okay?
Yeah, thank you, sir.
All right.
Excuse me, sir.
So
Excuse me,
with
sir.
that, I won't be able to take any other
Excuse me, sir.
question because I need to be in the exam hall now. So we can keep your question to our next class. Thank you very much and enjoy the rest of the day. Bye.
Thank you, sir.
Thanks, sir.
Thank you, sir.
Thank you.
Thank you, sir. To write
Thank
our
you,
names
sir.
and attendance, so the chat is